All right, welcome back to the Daily Facts. And this is part two of the Carter Page lawsuit. So let's get right into it. Defendant Lisa Page is a former lawyer at the FBI. She is sued in her individual capacity. Joe Pienka III, during the relevant period, served as a supervisory special agent of a foreign counterintelligence squad at the FBI's Washington field office. He is sued in his individual capacity. Stephen Soma, aka Steve Holt, is an FBI agent. He originally presented himself as Steve Holt to Dr. Page during a series of meetings in March 2017. According to the DOJ, OIG, Mr. Sama is primarily responsible for some of the most significant errors and omissions in the FISA applications against Dr. Page. He is sued in his individual capacity. Brian J. Outen was an FBI supervisory intelligence analyst. He is sued in his individual capacity. John Doe's 1 through 10, individuals whose identities or specific involvement in the conduct alleged in this complaint may not yet be known to the plaintiff, are sued in their respective individual capacities. Jane Doe's 1 through 10, individuals whose identities or specific involvement in the conduct alleged in this complaint may not yet be known to the plaintiff, are sued in their respective individual capacities. Jurisdiction and venue. This court has original subject matter jurisdiction over Dr. Page's federal claims under 28 U.S.C. 1331 and 1346b1 because they arise under federal law and because the United States is a defendant. This court has personal jurisdiction over the individual defendants who reside outside the District of Columbia, pursuant to D.C. Code 13-423A3, as plaintiffs' claims for relief arise from their acts directly or by an agent causing tortuous injury in the District of Columbia by an act or omission in the District of Columbia. This court has personal jurisdiction over the federal government defendants pursuant to 18 U.S.C. 2712, 28 U.S.C. 2674, 5 U.S.C. 552, AG 1D, and 5 U.S.C. 552A 4B. Venue is proper in the District of Columbia pursuant to 28 U.S.C. 139B2, because this is where substantial part of the events or omissions giving rise to the claims occurred, and this is where the government entities are located. The FISA applications and warrants. The FISA warrants were unlawful admissions and rulings. The 4 FISA warrants to surveil Dr. Page were obtained unlawfully because there was not probable cause to seek them. The warrants were issued only because of the FBI's omission and misrepresentations of the FISC. The December 2019 report entitled Review of 4 FISA Applications and Other Aspects of the FBI's Crossfire Hurricane Investigation, issued by the DOJ OIG Horowitz report, the analysis from the Senate Select Committee of Intelligence, findings in Special Counsel Mueller's report, and rulings of the FISC established that there is not and never was any evidence that Dr. Page acted in concert with Russia or its agents, because he did not, and that the 4 FISA warrants to surveil him were unlawful. The Horowitz report established numerous material failures by FBI to follow the Woods procedures and other DOJ and FBI policies. Among other things, the FBI failed to verify the accuracy of information included in the warrant applications. In many instances, the FBI either had no supporting documentation, misrepresented what the supporting documentation stated, or the supporting documentation showed that the factual assertion made in the application was incorrect. In total, the Horowitz report found 17 distinct significant errors and omissions in the FISA warrant applications submitted regarding Dr. Page. Since not a single proven fact ever established complicity with Russia involving Dr. Page, there never was probable cause to seek or obtain the FISA warrants targeting him on this basis. The DOJ now assesses and has formally admitted to the FISC that with respect to at least the last two warrant applications, if not earlier, there was insufficient predication to establish probable cause to believe that Dr. Page was acting as an agent of a foreign power. In this vein, two deputy attorney generals, Sally Yates and Rod Rosenstein, who signed and approved FISA warrant applications regarding Dr. Page, have testified they would not have signed the applications had they known of the misrepresentations and omissions at the time they signed the applications. Further, the DOJ has admitted in letters submitted to the FISC under FISC Rule 13A that there were material omissions and misstatements in the FISA warrants applications. These letters include, but are not limited to, the following: Preliminary Supplemental Rule 13A letter regarding applications submitted to the court targeting Carter W. Page, and document numbers 2016-1182, 2017-0052, 2017-0375, and 2017-0679, October 25, 2019. Supplemental Rule 13A letter regarding applications submitted to the court targeting Carter W. Page, and docket numbers 2016-1182, 2017-0052, 2017-0375, and 2017-0679, November 27, 2019. Additional Rule 13A letter regarding applications submitted to the court targeting Carter W. Page, and docket numbers 2016-1182, 2017-0052, 2017-0375, and 2017-0679, December 9, 2019. In addition, the FISC has issued several rulings authored by the former FISC chief, the Honorable Rosemary M. Collier, and the current FISC chief, the Honorable James E. Boasberg, finding that the warrants to surveil Dr. Page contained material omissions and misstatements, lacked candor, and or that the warrants were not lawfully obtained. For example, by order dated December 17, 2019, at page 3, the FISC stated, the frequency with which representations made by FBI personnel turned out to be unsupported or contradicted by information in their possession and with which they withheld information detrimental to their case calls into question whether information obtained in other FBI applications is reliable. And by order of January 7, 2020, regarding handling and disposition of information, the FISC states the court understands the government to have concluded, in view of the material misstatements and omissions, that the court's authorizations in docket numbers 17-375 and 17-679 were not valid. The government apparently does not take a position on the validity of the authorizations in docket number 16-1182 and 17-52, but intends to sequester information acquired pursuant to those dockets in the same manner as information acquired pursuant to the subsequent dockets. In order dated March 5th, 2020, the FISC said, there is thus little doubt that the government breached its duty of candor to the court with respect to those applications involving Dr. Page. The FISC then said, the frequency and seriousness of these errors in a case that, given its sensitive nature, had an unusually high level of review at both DOJ and the Federal Bureau of Investigation, have called into question the reliability of the information proffered in other FBI applications. Further, in an order dated June 25th, 2020, declassified on September 11, 2020, the FISC said, the government acknowledges that there were material omissions and the court has found violations of the government's duty of candor in all 4 applications regarding Dr. Page. In analyzing what lawful use may not be made of the results of the surveillance of Dr. Page, such as Dr. Page using them as proof in a lawsuit against the government, the FISC observed 50 U.S.C. 1809A2 and 1827A2 specifically addresses the circumstances of this case where we already know that information was obtained through unlawful surveillance and search. Emphasis added. While the DOJ admitted to the FISC that the 3rd and 4th FISA warrants were not valid, neither was it prepared to defend the 1st and 2nd warrants, as the FISC noted in its order of June 25th, 2020. As noted above, the government admits that at least the 3rd and 4th Page applications lacked adequate factual support. See December 9, 2019, letter at 219. It further admits that the restrictions on use or disclosure in sections 1809 and 1827 apply at least to information acquired under color of the 3rd and 4th dockets without addressing whether they apply to information acquired under color of the first 2 dockets. See February 5th, 2020, RESP at 28. In fact, in response to the court's directive to explain why retaining the Page FISA information in the manner intended by the government and any contemplated use or disclosure of it comport with 1809A2 and 1827A2. January 7, 2020, order at 2, the government declined to argue, even alternatively, that those provisions do not apply or apply differently to information obtained under the first 2 dockets. See February 5th, 2020, RESP at 28-29. Under the circumstances, the court will assume that 1809A2 and 1827A2 apply to information acquired under the color of the 1st and 2nd dockets, just as, per the government's admission, they apply to information acquired under color of the 3rd and 4th. Okay, we're going to stop there and we will pick up next time. Thank you for stopping by the Daily Facts. Do like, share, subscribe, and leave a comment below. We'll talk again soon. Bye.